Good afternoon, everyone, and welcome to the Anne F. Baum Memorial Lecture on Elder Law. This endowed lecture series is an annual tradition here at Illinois and is made possible by a generous gift from the estate of Anne Baum. Mrs. Baum was born November 11th, 1922. A lifelong resident of the Chicago area, she grew up with 7 siblings, and she and her husband, the late Alvin H. Baum, operated an investment firm in Chicago. Mrs. Baum and her late husband were compassionate individuals who supported a broad array of charities, as well as provided direct support to needy individuals. Beneficiaries of their giving included the disadvantaged, the young, the elderly, religious organizations, educational organizations, and civic organizations. Their legacy of giving and sharing is continued through the Alvin H. Baum Family Fund, of which both Alvin and Anne were benefactors. In remembrance of her life, a gift through her estate endowed the Anne F. Baum Memorial Lecture on Elder Law here at the college. This lecture series seeks to promote the relevant and timely discussion of a broad range of legal issues relating to the intersection of public policy, the law, and the elderly. It constitutes a fitting memorial to a woman who deeply was concerned with the rights and issues pertaining to elderly people in our society. And so with her in mind, I introduce today's speaker. Abbe Gluck is the Alfred M. Rankin Professor of Law and the Faculty Director of the Solomon Center for Health, Law, and Policy at Yale Law School. She is also a Professor of Internal Medicine at Yale School of Medicine and a Professor in the Institution for Social and Policy Studies at Yale. Professor Gluck is one of the nation's most highly accomplished and widely cited scholars. She is an expert on Congress and the political process, federalism, civil procedure, health law, and is chair of the section on legislation and the law of the political process for the Association of American Law Schools. Professor Gluck's scholarship has been published in the Yale Law Journal, Harvard Law Review, Columbia Law Review, as well as a plethora of other journals. In 2015, she was both appointed by the governor of Connecticut to serve on the Uniform Law Commission and elected to the American Law Institute. In addition to her influential research, Professor Gluck has extensive lawyerly experience at all levels of government. She served in various capacities in the administrations of New Jersey Governor John Corzine and New York City Mayor Michael Bloomberg. Prior to law school, she worked in the U.S. Senate for Senator Paul S. Sarbanes of Maryland, and following law school, she clerked for then Chief Judge Ralph K. Winter of the U.S. Court of Appeals for the Second Circuit and for U.S. Supreme Court Justice Ruth Bader Ginsburg. From November 2020 to November 2023, she served as special counsel in the Office of White House Counsel, working with the administration's COVID-19 response team, as well as on other issues, including the Affordable Care Act. More locally, she founded and directs the Yale Law School Legal Partnership Program, a clinic that provides poverty legal services across New Haven. Without further ado, I introduce to you today's speaker, Professor Abbe Gluck.
I'm blown away by the amount of people at this law school who are interested in elder justice. It's really amazing to see, and such a testament, Professor Kaplan and the whole program and the interest in elder justice he has created. So thank you, Professor Kaplan, for the invitation and for creating this community. Really fantastic. And you have, I'm sure you know by now, just an awesome dean in Dean Sharp. He is fantastic. I have many memories of us as youthful law professors at conferences. We written, or our work on federalism is overlapping, and he is a favorite face to see at any conference. So I hope you all know how lucky you are to have such a great dean. So thank you for that ridiculous introduction. And I also want to thank the Baum family. So I'm not using a PowerPoint, I apologize. I want to talk to you about a lot of things today, and I need to do that with my voice and not with a PowerPoint. What I want to say, just to frame what I'm about to talk about, is one of the things that, can you all hear me? Is this fine? Yeah, I'm back, okay. One of the things that is so special about this lecture and the program that Professor Kaplan has created is that every year he brings in people who aren't necessarily just doing elder justice. They're situating elder justice in broader landscape of public law and health law. The health law program I direct has an elder law project, and we conceive of elder law in that same way. But in so doing, he's making a point about the relevance of elder justice issues to all of us across the spectrum. It's not just about nursing homes. It's not just about this population. It's about all of us, and that's really important. I prefaced my talk by that today because what I'm going to talk about today is a subject very much linked to elder health care on the one hand, that's preventative care, but I'm actually going to situate my talk in a much bigger set of questions about continuing fights over the Affordable Care Act and the policy reforms it accomplishes, and also this very important term at the Supreme Court in terms of the future of the administrative state and deference to scientific expertise. So I'm going to focus my remarks around a case called Braidwood versus Becerra. This is a challenge to the Affordable Care Act's provisions that require some 200 preventative care services. What do I mean by that? Vaccines, cancer screenings, hearing tests, heart disease medication, much more. We'll get to all that in a minute. Those provisions make those free to consumers. I say free with quote marks. They're not really free. We don't pay for them. They require insurers to pay for them for us, but we don't pay a dime out of pocket for those. The Fifth Circuit heard this very important appeal, which is likely going all the way up to the court, this past Monday. And my goal today is not to get into the nitty-gritty of the legal arguments, although I'm going to briefly talk about them so you can sound smart at cocktail parties. But I want to situate this debate in broader debates about healthcare, the court, and the administrative state, and of course, how it relates to the interests of older Americans. So I'm going to provide a little more detail about the challenge in a moment, but first I have to get some crowd participation. I cannot talk about the subject of preventative care without telling you a story. I do this every time. If you heard me say it before, I apologize, but I don't recognize too many of you, so hopefully you haven't heard this story before. I have twin boys. They are 17 years old. They're really tall and they're awesome, okay? So when they were little, I also have great insurance. Aetna from Yale is a fantastic insurance plan. I have wonderful coverage for all sorts of things. When they were about 2 years old, we had their wellness visit. They got a whole bunch of shots, like you expected any wellness visit. And I'm used to getting like the $20 copay visit bill from my doctor. I got a bill that was several $1,000s. And I call the pediatrician. I say, oh, must be a mistake. None of the shots were covered. And they said, yeah, your insurance doesn't cover them. I said, no, I'm a health law professor. Of course insurance covers them. Okay, start doing some math in your head, okay? So fast forward, I know lawyers don't like math, but this is easy math, okay? So fast forward 6 years, I have another kid, she's great, she's 6. She was born in 2012, she's 11 now. I go to the doctor for her, we have the same wellness visit, she gets the same series of shots, and I don't get a bill this time, right? So what's happened between the time my children were born in 2007, and the time my daughter was born in 2012? The answer is 3 words. What are those 3 words? ACA, right? Affordable Care Act, okay? 3 words happen. So this is the story I like to tell about how the Affordable Care Act has made things feel accessible to us that we all feel should have always been accessible to us. We start to take for granted the kind of health care access we should get, and there's always this moment of shock. How come my children's child care vaccines aren't covered when so many other things you would expect to be covered were covered? Now we all have the same anecdotal story to share. I'm not going to call anybody out, but I'll ask you to ask yourself, has anyone in this room gotten something called the COVID-19 vaccine? Maybe, right? How many people paid a dime for that vaccine? No one. From the community health center to the CEO of the boardroom paid a dime for that vaccine. How is that made possible? Again, by the Affordable Care Act provisions that are under attack in this case. So let me talk to you a little bit about what that provision is, and then we'll talk about the bigger issues in the case. The provision is called the Preventative Services Care Provision. And by the way, the ACA is passed in 2010. That's the difference between my children's ages, right? So Preventative Services Care Provision designates a process by which the recommendations of 3 long-standing expert agencies that have been in business for 40 years, long before the Affordable Care Act, these agencies make recommendations about evidence-based preventative care services that they believe everybody should get. it takes that process and says, for those services recommended by these expert agencies, if you want to know the names of them, U.S. Preventative Services Task Force, HRSA, and ACIP. Those are the names people use. Any of those are supposed to be made cost-free to you by your insurer. That's the innovation of the Affordable Care Act. Medicaid basically tracks the recommendations, so it achieves the same result. And so what does this have to do with seniors? First of all, 69% of adults ages 50 to 65 are in the private insurance system, so it obviously affects seniors. Second, Medicare, Center for Medicare and Medicaid Services basically designates most of these services also to be covered for Medicare. But more importantly, if you step back, it's absolutely critical for Medicare's financial stability that we have a healthier older population, right? We need to do all we can do to ensure that people age into Medicare at age 65 as healthy as possible. And we'll talk to you a little bit about how having early high-quality health care earlier, including necessary preventative care, is critical to have healthier Americans in Medicare, which will in turn will contribute to Medicare's long-term financial stability. Okay, so on to the challenge. This is the legal part. So one challenge is non-delegation. The idea is that Congress gave this big decision to these expert independent agencies with no guardrails. In fact, Congress says every recommendation has to be evidence-based, and these are the kinds of populations that we want you to deal with. So for example, HRSA has to deal with women and children, ACIP deals with vaccines, the U.S. Preventative Services Task Force deals with the broader population. Another prong of the challenge has to do with the Appointments Clause. Who are these people on these task forces and who is supervising them? If you're taking administrative law, you know this is a big set of issues. Third is about religious freedom. The plaintiffs were religious individuals and companies who objected on religious grounds to the Preventative Services provisions. Why? They cite their rights under the Religious Freedom Restoration Act because they don't want to pay for an insurance plan that includes a specific medication called PrEP, which is a prophylaxis against HIV. So the argument is that by buying these insurance plans, by participating in the Affordable Care Act's preventative services care provisions, we are morally endorsing and, in fact, financially supporting the kind of sexual conduct that we find problematic. So we're going to talk about all of these things, but those are the three prongs of the challenge. So first, I want to talk about the Affordable Care Act. I want to make no mistake that this attack is an attack on the Affordable Care Act writ large. The act is almost 14 years old. It survived 7 trips to the Supreme Court. The 8th one is coming later this month. There have been more than 70 attempts to repeal it, a change of congressional control, 3 different presidents, and more than 2,000 lawsuits. It's also been a huge success. Apart from the vaccines, if you look just at the COVID-19 pandemic, the insurance rolls swelled, both public and private, to meet the needs of a population in an unprecedented health crisis. I've said this over and over again. It is an unsung hero of the Affordable Care Act, of the pandemic, providing a safety net function that was always there but hadn't always been called to the fore as one of the ACA's benefits. And in the world of legislation scholarship, which is the other world in which I live, this statute bears the trappings of what we might call a super statute, a statute that was at first controversial, has survived massive contestation, including political electoral debates and electoral challenges, and has emerged in ways that it has become entrenched in the fabric of our lives, such that it starts to change the way we think about our rights, our right to access a vaccine, right, our right to access a doctor, in ways that make it especially entrenched, not constitutional law, but part of the fabric of the way we understand our rights. And so one question is sort of, why are we still fighting over this law after 14 years, right? And the second question is this challenge to under Braidwood, the Preventative Care Services provision, just sort of a wonky little thing, or is it actually an important challenge about what goes to the heart of the Affordable Care Act? And I want to make the argument to you that while it seems to be in the weeds, it actually strikes at what's a fundamental philosophical change that the Affordable Care Act wrought, and that's why it's so important. So one thing I want to remember is before the ACA, you have to remember, and most of you are too young to even know this, people were discriminated against in access to health care. Certain groups had a harder time getting access to health care than others. Insurers openly discriminated, for instance, against gay men because they did not want to pay for HIV. insurers openly discriminated against women because pregnancy is expensive. People used to walk around saying being a woman is a pre-existing medical condition that justified your denial of insurance. Okay, that was the world before the ACA. And in the public insurance context, Congress discriminated because Congress set out categories of who was eligible for Medicaid. So here's another crowdsourced question I used to ask in 2011, maybe 2010. In 2010-ish, 2011, after the Affordable Care Act was enacted, but before it was implemented, I asked people, if you are a poor man living in Nebraska, way under the poverty line, do you have access to Medicaid? Everybody says, sure, of course. Medicaid's for low-income people, right? No! Actually, Medicaid was for mothers, pregnant women, children, not for regular poor men. This is a huge change that the Affordable Care Act wrought. It transformed the idea that we don't discriminate on your access to the healthcare system because of who you are. Okay? That is a fundamental philosophical change. And that premise is what Braidwood is attacking. And with respect to the population 50 and over, it has already been well documented that existing healthcare disparities increase as people get older. The idea of giving everybody access to the system is a way that has been proved to reduce harmful and discriminatory healthcare disparities across the lifespan. And that's an important goal if you're thinking about this case in the context of elder justice. Braidwood instead threatens to restore this idea of the deserving poor. I'm going to go back here. I lost a page of my thing. So let me go back and just say something that I wanted to say to you, which has fallen out of my notes. Before the ACA, there was this concept about the deserving poor, this idea that only certain populations were deserving of insurance. The elderly, Medicare is actually a perfect example of the deserving poor. They were a special population that we really wanted to take care of. Then Medicaid built some other categories, right? The ACA gets rid of this overarching concept, but Braidwood brings it back. And it brings it back because it's a moral attack. Yes, on this one population, the gay male population. But it doesn't have to be the gay male population. The next week, it could be a different population, right? First of all, the gay male population, many of whom are HIV positive. The amicus briefs in the case have pretty extraordinary statistics on the number of people who will be aging into Medicare with HIV who could benefit from this drug. It does affect Medicare for that reason. But tomorrow, the challenge could be to blue-collar workers. I don't want to participate in a plan that screens them from lung cancer because I don't have that kind of job. Why am I paying for that? Or to rock musicians. I don't want to pay for a plan that screens them for hearing loss because I don't listen to loud music. Or to people who are overweight. I don't want to pay for the new really expensive diabetes drugs because somebody can't control themselves at McDonald's. Or single women who are pregnant. I don't want to pay for single women who are pregnant. They got themselves into trouble, right? Do we want to go back to a healthcare system where people, courts, litigants, are making judgments about who deserves to be in and who deserves to be out? That's what the case is about. Happy to talk to you in Q&A about why you're not going to hear about this RFRA challenge if you're following the court case. The government did not challenge the lower court decision on the RFRA decision. So Judge O'Connor in Texas actually agreed with the plaintiffs that their religious rights were violated by having to pay for this particular prophylactic medication. But Judge O'Connor in Texas limited the remedy to the 7 plaintiffs. So it was very confined. The government made a strategic decision not to challenge that. So we can talk about that afterward. But I want to say litigation strategy is one thing, but they didn't challenge that. What's to stop the next case? What's to stop the slippery slope of all the scenarios I just gave you, where you, someone you care about, a group you care about, is the next one that gets excluded from health coverage? Second, the case strikes another really important and fundamental part of the ACA. That is the ACA's effort to move the whole healthcare system's philosophy from one of individual, I get what I can pay for, to community, solidarity. We all deserve to be in the same insurance pool. We all take care of each other. We can't predict what's going to happen to us over a course of a lifetime. We all get insured. Medicare is a quintessential example of that solidarity approach. Everyone gets in. as opposed to the old-fashioned private insurance system where some people were in, some people were out, you got the health care that you paid for. That was an incredibly important philosophical move, and it would have been even more transformative had the Supreme Court not rendered the Medicaid expansion optional. There are now about 10 states left that have an expanded Medicaid, but we are getting there, and soon there will be this philosophy across the country. But apart from the story of the deserving poor, what I want to say now is it's important to see that the ACA's transformation of this approach to one that is solidarity-focused is actually related to the preventative care philosophy, and I want to explain to you why. Apart from this question of the deserving poor, one of the other big divides in health policy for a long time has been this question about public health and prevention versus medical care on the other side, right? There's always been this idea these are two different worlds. There's the world of disease and treatment, and there's a world of public health and prevention. This goes back until the beginning of time. There's a wonderful chapter in Paul Starr's famous book, The Social Transformation of American Medicine, where he talks about how in the 1800s, these two worlds were kind of carved apart. And I'll give you one example to kind of put a pin on it. And keep in the back of your mind, part of what's going on here is that it's not politically exciting for Congress to legislate when it comes to public health and prevention. Why? It takes a really long time, not 2, 4, 6 years, to recognize the benefits of public health and prevention investment. The other problem is it's really hard to budget for public health and prevention legislation, and Congress budgets in a 10-year window. Okay, if you're trying to budget the effect of tobacco cessation over 10 years, the value is going to cost you more on the front end. You're going to get less on the back end. But if you did it over 50 years, wow, would you see a benefit? So as one example from a chapter that I wrote during the COVID-19 pandemic, just an easy statistic, there are 1 million like them. The National Cancer Institute's annual budget is $6 billion for medication-related research. Okay? That's a lot of money, $6 billion. The CDC's budget for annual cancer prevention, $350 million. $6 billion versus $300 million. By some statistics, public health accounts for 70% of the population's health. It receives less than 3% of our federal dollar investments. So a prevention approach is not exactly the same as a population or public health approach, but it shares the same philosophical underpinnings. It's also worth recognizing something that a great amicus brief written by one of my former students, Erica Tourette, in the Braidwood case, points out that our healthcare system remains fragmented, ACA aside. We still have Medicare, the private insurance system, Medicaid. You still tend to jump around between health plans during your lifetime, and hopefully all of us wind up on Medicare. Because it's fragmented, you can't just say this part of the system doesn't get preventative care, because you wind up saddling Medicare on the back end with all of the unhealthy people who didn't get the preventative care that they deserved. So if we say, okay, during the time you're on the private insurance rolls, you only get the preventative care you pay for, we're putting Medicare in a very difficult position, particularly as we're entering a period where we're going to have the largest elderly population in American history. All of these experts in aging now who are writing about our boom that's coming with respect to our elderly population are not just concerned about longevity. They're concerned about a healthy lifespan, right? We want a good old age, a healthy old age, not just a longer and more expensive old age. Prevention is critical. The U.S. National Academy of Medicine just released a global roadmap for healthy longevity. It went out of its way to emphasize this idea of public health, prevention, and a population-wide approach to aging. And then there's a related trend here. In addition to our aging population, in health policy, we are finally seeing a recognition that it's more than just medicine that keeps you healthy. There are social determinants of health, access to nutrition, housing, benefits, exercise, right? Healthy vegetables that contribute to a longer and quality life. The Medical Legal Partnership, which I direct at Yale, is at the forefront of that movement. I'm very proud of that. But the same Institute of Medicine report that was talking about a healthier older population is also emphasizing this more holistic approach to health. Let's think about all the different ways in which we prepare to have a healthier older population. Why am I mentioning this? It doesn't make sense to be making great progress in this idea of a more holistic approach to health and then cut the legs out of the same goal by denying everybody preventative care, right? You're not going to get anywhere unless you put all these tools together. So they are related. There's a lot more I could say about this, but I want to get to my final point. So I'll just give you a few statistics, and I'm going to move on. Routine childhood immunization of one birth cohort prevents more than 40,000 early deaths and 20 million cases of disease in adulthood. Every $1 spent on childhood vaccines translates to $10 in savings, $10.90. With respect to older people in particular, and by the way, vaccines, these are things that can be cut by this case. All the things I'm about to talk to you about are things that are on the chopping block in this case. With respect to older people in particular, there are a series of medications that are evidence-proved to prevent heart disease and maintain health. Between 2016 and 2022, the USPTSF, the organization under attack at the heart of the Braidwood Challenge, recommended statins, which is a certain kind of medicine for cardiovascular disease, for all Americans that are at risk. An average, estimated 80 million Americans have one form of cardiovascular disease. Half of those are over 60. Bye-bye to that. USPTSF also recommends preventative medication to women at increased risks of breast cancer. 83% of invasive breast cancers are diagnosed in women 50 age and over. 91% of breast cancer deaths occur in this group. Certain medications, including selective estrogen receptor modulators, have been proven effective at reducing the incidence of breast cancer in this group. USPTSF has recommended annual lung cancer screenings for older adults. Lung cancer is the second most common cancer, the leading cause of cancer death in the United States. Two key risk factors, smoking and being over 50. When detected sooner, early stage lung cancer has a better prognosis and is more amenable to treatment. When detected sooner, right? Not when you're 70 and on Medicare, but how about getting detected when you're 52? USPTSF also has recommendations concerning injury prevention that are very important to older adults. They've expanded the recommendations about osteoporosis screening. 10 million people over 50 have osteoporosis. About 30% of patients who have a hip fracture die within a year. It's a pretty shocking statistic. All of those protections, plus, I gave you 180 more, the 183 on the chopping block, are on the line with this case, and the broader philosophical point. So the implications of the case are just enormous, and the way that we don't talk enough about public health and prevention are just huge. So I'm going to digress briefly before getting to my administrative state point, because I also can't talk to you about investing in a population-based approach without talking to you about the geriatric workforce. Okay, so I have a chapter in a book coming out with Linda Fried and Yaron Kovo. We're pulling together a lot of the themes that I'm talking to you about today. And we're arguing that workforce issues go hand in hand with preventative care and investment in the elderly population. According to one estimate, there are only 7,500 certified geriatricians in the United States. Taking care of older people is not the same thing as taking care of younger people. Older people have complex chronic conditions. They have different needs. Medications affect them differently. There are different balances that have to be undertaken. By the way, 7,500 certified geriatricians, 50,000 OBGYNs in the United States. By way of comparison, after the baby boom around World War II, we didn't have a lot of pediatricians, but they swelled. Between 1938 and 1955, the number of pediatricians tripled in this country. By the end of the 1960s, they almost quadrupled in size. The number of geriatricians today is almost exactly the same as it was several decades ago, despite the fact that we are about to increase a huge boom in elderly people who need medical care, right? The point is that we're not thinking about how to prepare for a healthier, older age. Preventative care is one piece of it. All the other things we've talked about, population health, investing in the medical workforce is another. So now I'm just going to step back and conclude by just situating all this in some broader debates in the Supreme Court. This is perhaps the biggest term in modern history for the future of the administrative state. Right? I don't know how much any of you guys know about this or if you've taken administrative law yet, but over the last few years, the court has made it much more difficult for Congress to delegate policymaking to subject matter experts and agencies. A series of decisions about structuring how agencies are structured, who makes the appointments, who supervises them. That's one set of cases and precedents that are all implicated in the Braidwood litigation. Because part of it is how much authority or not Congress has actually given to those expert bodies, and should they be sort of supervised by HHS. You know, as one digression with that regard, I will just tell you that 1/4 of the preventative care services in the ACA were actually added to the statute on the Senate floor following a really contentious debate between some senators over how often women should get mammograms. Yeah, thank you for the laughter. Okay, so there's this huge, so the ACA is going through Congress. They're having this debate where the Senate is going to legislate on how often women over 40 or 50 should get mammograms. Barbara Mikulski, who, to be fair, was part of that debate, then turns around and is like, let's give this to some experts. Let's take this out of the Congress, off the floor, and to an expert body. That kind of delegation to an independent body that is still supervised by HHS is what's at issue in the administrative law challenges. Okay, second, the Supreme Court has coupled those decisions about delegation with a whole host of other decisions that are basically asking the Congress to legislate with enormous specificity. These decisions are known as the major questions doctrine, where the court is saying that Congress can't delegate policy ideas with broad swaths to agencies, but they have to basically predict the policy problems that are going to arise and tell expert agencies how they should answer them. Right? This is an impossible task for Congress to do because Congress is not an expert. Congress is consumed with politics, and it's a particularly difficult task for a field like science, right, which evolves with new data and new expertise. We don't want Congress to be bound. We don't want the CDC to be bound to a statute that is 75 years old if Congress has to legislate with such particular specificity about what it can do. This year, we also have a major case coming to the court about about medication abortion. This is the mifepristone case. Some of you might have been following it. Oral argument is the end of this month. And the question in that case is whether the court should substitute its own judgment for the expert judgment by the FDA that this medicine is safe. This case is not about Roe versus Wade. This case is about the FDA 20 years ago determining this particular pill was safe, and a court now deciding, oh, we'll take a look at those lab reports and let's decide for ourselves. Even though the older population may not have much invested in the medication abortion debate, they should be invested in the question of who's making decisions about the safety of drugs and which drugs get on the market. Finally, we have another series of cases moving through the federal courts challenging the constitutionality of provisions of the Inflation Reduction Act that, for the first time ever, give Medicare the right to negotiate with drug manufacturers over their prices. You may not have realized this, but when Medicare Part D, the drug part of Medicare, was enacted in 2003, it was controversial. The drug lobby is very powerful, and they basically got an exception. Okay, we can be part of Medicare, but we set the prices, and nobody gets to negotiate with us over what those prices are. It's remarkable that it's taken this long for that process to start to be eroded. The Inflation Reduction Act has a limited program that targets the highest grossing, highest priced drugs and finally allows Medicare to negotiate with them. Of course, drug companies are now arguing that because they've had 20 years of this benefit, that has now become a constitutional entitlement to have it forever. That is actually the argument. It is a property right. You're laughing. It's a property right argument. We've been given a cookie for 20 years, so now I have a property right to a cookie forever. Those cases are moving through the courts, including in this state. I mention all of this because if we're doing a tour through what's happening in the courts at the intersection of elder law and healthcare and the regulatory state, this all has to be part of the mix because it goes to this question of the government's involvement in the healthcare system and the kinds of guardrails the government are able to place on the system in order to ensure this financial stability of Medicare, which is a big part of the Inflation Reduction Act reforms, but also to ensure that everybody gets access to the health care that they need. Drug prices are very high. The ARP says that many people go financially bankrupt or have huge financial difficulties paying for them. The CDC estimates that many elderly people don't adhere to their prescribed medication because they can't afford it. and failure to adhere to your prescribed preventative care contributes to more than 30 to 50% of chronic disease treatment failures over the course of a year. So the last thing I'll say is that you probably all know that we have two other huge cases currently pending for the Supreme Court, the Loper case and the Relentless case, which are linked. These are cases where we are challenging the future of the most cited case in the US reports. Not the Erie Doctrine, my favorite case, used to be number one, but have taken over is Chevron. So Chevron deference regime, the precedent that says that we courts will defer to the expert judgment of administrative agencies when statutes are ambiguous. That case is very likely to be overturned this term or significantly curtailed. That would be a sea change in the relationship among the three branches, and in particular among the relationship between courts and executive agencies. What does all this have to do with Braidwood and the ACA? Everything. Why? We're seeing this full frontal attack on the idea of expertise and the idea that politicization of scientific and other complex questions is a better answer than delegation to those who have views informed by evidence. Braidwood, along all sides of these other attacks on the administrative state, threatened to bring us back to that moment where we're debating when women should get mammograms on the Senate floor. And the thing is that Congress can't legislate with the kind of specificity that the court is asking Congress to legislate with. It just can't. It doesn't have the knowledge and doesn't have the political ability. And the court at the same time is saying that administrative agencies can't do all the things we've relied on them to do for the last 40 years since Chevron was passed and long before. But if Congress isn't legislating with specificity and the administrative agencies aren't doing what they're supposed to be doing, who becomes the decider? Four guys, not guys, more women now, 5 guys and 4 women in Washington, right? So the courts, right? Not just the Supreme Court, but all the courts, right? And I don't think anybody, whatever you think about the administrative state, whatever you think about any of the topics we've talked about today, I don't think anybody thinks that courts should be the deciders of whether adults over age 50 should have access to heart medication or cancer screening or any of the other 183 services that we're talking about that for the last 14 years, people have got cost-free. And I do hope what I've done today is just convince you about how central those services are, not just to everyday lives, but to the philosophical progress that the Affordable Care Act has made and that many of us take for granted, as well as the related goal of ensuring that as more and more Americans age, they age healthier, they have better lifespans, and that Medicare remains fiscally sound rather than saddled with the burden of an unhealthy, huge older population that didn't get quality care when it was younger because they couldn't afford it. And with that, I'll take your questions.
Brilliant and compelling, thank you. So, question time. Professor Mazzoni, as when he was a student, had his hand up first. Go ahead.
Thanks so much for this. It's super interesting. I wanted just to invite you to say something about something. You said you would say something about the Q&A, which is the RFRA piece of this in the current context of CRAB. Just to sort of tee up the question, it did seem to me that when the ACA was being rolled out, the administration was, I think, insensitive to religious objectors. And it took a long time for that to sort of be worked out through negotiations and then some Supreme Court decisions. And so this time around, is that story going to be repeated? Or do you think this is just an easy case for application of RFRA? What are your thoughts about that?
Well, it's a couple things. So when the ACA, first of all, good to see Brooklyn blood in Illinois. So I started my career at Brooklyn Law School. I love that. I love that place. I love that place. And so, okay. So I think, let me step back. When the ACA was enacted, what Professor Mazzoni is referring to is there were early battles over cost-free contraception being part of the preventative care. That's one of the many things you're referring to, about cost-free contraception being part of one of the things that has been covered. Again, I would just step back and say, that's not part of the ACA. It's part of the preventative care provisions, right? So what the ACA was trying to do was precisely this. And I don't know if you guys, it seemed like a genius move. I remember I basically made some obnoxious comments like, oh, they're punting, okay? Because there were a lot of fights around the time about what's going to be covered and what's not going to be covered. And Congress really couldn't answer those questions. So what happened was Congress did two things. They outsourced the essential health benefits package, like what has to be covered by private insurers, essentially to the states, and said, here are some guidelines, but take it. And then that's why some states have IVF covered, some states don't. There's movement among those different states because Congress just could not make those political determinations. And with respect to contraceptive care and breast cancer and lung cancer and all the other things we've talked about, they gave it to these expert agencies. So whether it's insensitivity to religious interest or just a feeling that when it comes to sort of evidence-based preventative care, Congress is not the place to make those, that's the decision that they made. Now, the administrations, you are right, in the last 14 years have had a whole host of regulations that deal with conscientious objection and religious objection to various kinds of healthcare provision services. That has been a really complicated area. I have to say that with respect to the RFRA provisions, I think there's an argument to be made that a plan that covers hundreds of preventative care services, of which we're all going to find something in there that we are going to disagree with. I actually think that there's personally, I don't want courts drawing the line between what counts as a religious objection and what doesn't, but it's a complicated question. DOJ, did not repeal that. We're not going to hear more about the RFRA part of this case because they basically conceded it out of the case because the District Court in Texas decided to limit that holding to the 7 plaintiffs. So now the rule is that those 7 plaintiffs don't have to pay for health plans that include this preventative care medication for HIV, but everybody else still does. There was actually some debate on Monday at the oral argument about how far that District Court's opinion should go. Should it be a nationwide injunction or not? I think if you start to see a broader application of its ruling, you're going to start seeing these issues come to the fore. The court in Texas sort of surprisingly cabined it and made it very small, and the government obviously decided that it was safer to limit the damage. And I understand that from a litigation perspective. I think when you're thinking about it from a big picture perspective, you don't want to have this be the beginning of little small pockets of the country where these 7 people don't have to provide for this kind of service, these 7 people don't have to provide for another kind of service.
Isn't this an easy RFRA claim, though? I mean, what's the...
It depends how you feel about whether you're paying for a broader plan that includes a prophylactic drug. You're not endorsing any kind of particular kind of behavior. You are, I would say, I also disagree with the previous positions on Hobby Lobby, but I think some people think it's different from the contraception case because you're not actually paying for something that does the thing that you object to. You're paying for a series of preventative care medicines for something that might have 2 steps removed. That's an argument that's been made about how it's different from what came before. I don't think we're going to hear argument on that now, thanks to what's happened.
Yes.
Thank you. My name is Elsa. I am worried about the implications of the ACA litigation on the medical legal partnership model because I believe that the ACA incentivized the model in non-profit hospitals. And so I'm worried what implication this has on the model. Thank you.
Right, so so medical legal partnerships, I don't know how many of you know what they are, but they are poverty legal services clinics that exist at the site of medical care. And the idea behind them is that, you often get doctors that have a patient where they have a medical problem, but they have so many other things going on in their lives, and they desperately sort of want to help their patients, and they can see that all those other stresses are causing stress that's affecting their well-being. Before we founded the medical MLP at Yale, I would get frantic calls from various palliative care doctors saying, I have a patient who's dying, and they're about to lose their house, and they're under so much stress, and I want to help them, and what can I do, and I need a lawyer. And we have lots of different models of MLPs that involve all different populations, including former immigrants, those returning from incarceration, all of these different areas in which healthcare is delivered at the site of medical care because that's a place where people tend to have some trust. Many populations don't seek out legal counsel. They don't go to legal services. They won't go seek a lawyer. They're afraid that I'm undocumented, so I can't ask a lawyer for help with something else. But by having a doctor say, hey, here's my friend Dean Sharp, I trust him, he works with me, maybe he can talk to you about your housing problem, that's what the MLP does. You're totally correct that the ACA actually financially incentivizes the development of these MLPs, which is just terrific. I don't think the current case has any effect on that, hopefully. Apart from the extent to which doctors involved in the medical legal partnership model are providing these preventative services. But I do think the whole philosophy of the MLP, which is this holistic person healthcare, preventative care has to be a piece of that. That's why I mentioned the social determinants of health. It's very strange to be sort of funding and incentivizing these MLPs and then say, we don't care about prevention. I think we're obviously entering into an election cycle. I mentioned the ACA as a super statute earlier and all of the challenges. We have a likely Republican nominee who has said that he still wants to get rid of the statute. The statute has been very resilient. I'm optimistic that the statute will survive, but it might be bitten apart along the edges. And, you know, MLP funding could get a piece of it. So actually, the Congressional Appropriations Committee, for the very first time, give out a lot of federal grants for MLP. The first time was last year. And if priorities change and healthcare becomes less important, then that model could suffer.
And by way of full disclosure, we have a medical legal partnership clinic. I don't know if
Anyone in it?
has enrolled in it with Land of Lincoln.
What's the population? Like everyone? I can't hear it.
They're like around Champaign. There you go. Oh, sorry. We do a couple counties around Champaign, I believe. Don't know the exact.
It's a great opportunity for direct client services, and it's not actually healthcare. You're actually doing poverty legal services at the site of care. So if students are interested in doing poverty legal services, which I know many of our students are, it's a really great way to interact directly with real people and to help them in a very immediate fashion, actually.
Do I really need one of these?
Well,
Okay. All right. Thank you so much for that analysis. It was fascinating. I did not realize how much had changed since I was a little child in healthcare. So my question now that we've sort of done this analysis, what are the steps forward, both on two counts? One, to build off of Dr. Mazzone's question, it seems that even though the Texas court sort of couched this RFRA issue and the government ignored it on appeal, it seems likely that these will proliferate. And obviously, if we can get an exemption for any individual thing, the whole system falls out from under itself like a Jenga tower. And then the other thing is, if we see Chevron disappear, what is then the next strategy to keep these provisions working? What is the sort of, where do we move the chess pieces now to avoid the court's decisions?
those are two great questions. On the RFRA, I'll just state the obvious, which I maybe didn't make explicit enough. Over the course of the COVID-19 pandemic, we saw a big change in our current Supreme Court's both composition and the way it's treating claims under RFRA, right? Our court became much more friendly to claims about religious freedom. I think an important strategic reason that the government did not go up on appeal is that it doesn't want to ask this court right now, right, to opine on that question. I think part of a challenge with all of these healthcare cases is that people don't realize, you said, one Jenga piece, the effect it has on the whole healthcare system and on the underlying philosophical components. So it might be pretty easy for the Supreme Court to say, okay, this medication, this RFRA claim makes sense here. When you start to unravel things, the whole thing falls apart. And I think one of the things that the advocacy community has gotten much better at, and that the administration was not good at, the Obama administration, is explaining what the Affordable Care Act is and how much it has actually changed. Like, you just gave me an idea. Like, I'm going to come up with some lecture for the next one of these where I'm going to say, like, when you guys were born and now, because you don't realize all the things that have changed. I don't have a good answer for you on the RFRA. This court is very RFRA friendly. I do think we have justices, even in the conservative bloc, who care about consequences and they care about system disruption. And I think that the argument that has to be made to them is that exactly your Jenga argument, you can't treat this as an isolated incidence of one medicine and one health plan, but you have to play out the way I played it out for you about obesity, about rock musicians, mine workers, et cetera, because I think that will play to their big picture thinking more clearly. With respect to Chevron, it's very hard to know. So 2 quick things I want to say about Chevron. There's a famous case called Meade, which you might have read in class, but now it's like leaving the case books because of the death of Chevron. But in Meade, Justice Scalia writes a dissent where he basically says, look, the thing about Chevron is that it prevents ossification. It allows an agency to change its mind. And yeah, maybe that means, oh, we get a Biden administration and a Trump administration, and the Clean Air Act looks kind of different under both. But it also means that as medicine or norms evolve, the meaning of statutes can change appropriately. If you lose Chevron, you go back to what was called Skidmore deference, which is when the agency would suggest the best reading of the statute and the court would adopt it or not. That becomes a precedent. The agency can't change its mind. Peter Strauss of Columbia has a great article called Skidmore Weight in Chevron Space. And the idea was that Chevron created a space for the agency to legislate and move things around. Skidmore just creates a weight for a one-time precedent. A big danger would be if the court goes back to Skidmore, because what does that mean? You're going to get a race to the courthouse. Everyone's going to try to lock in their preferred meaning of every statute today. I don't think X constitutes pollution. I don't think X constitutes a child if they're born from a surrogate, et cetera, right? You don't want that kind of ossification of federal law. At oral argument, some of the justices, the conservative justices, started to hint that there might be a new way for the government to start legislating by just incorporating terms like reasonable, right? Writing statutes with more guardrails that kind of give the agencies specific areas of deference, but not to the statute as a whole. So for example, we have had some fairly ridiculous cases where there's a question about what the meaning of the word a is, or the meaning of the word so is, right? And you're in a Chevron deference land. Well, does HHS know what the word a means over me? Maybe not. And you can see how those kinds of cases would get on the nerves of judges who say, we know how to read statutes better than anybody else. But when you get to a word like, poisonous, or you get to a word that has some kind of expertise behind it, you could see more delegation. And I think the shiniest version of Chevron is one in which we get to a place where the court says, look, Congress, for stuff like that, reasonable construction of pollution, Congress is sort of signaling this is an area where we want the agency to get expertise. I think a problem with that, so that was the happy version of the Chevron oral argument, and a lot of people reported feeling the same way. But I don't think all of those people were also thinking about the major questions doctrine, which I said to you before. The major questions doctrine says Congress can't give really big questions of social, political, or economic significance to the agency unless they explicitly say so. So the court is going to have to get comfortable with Congress saying, we want the EPA to give us a reasonable definition of pollution, and we are explicitly saying that we want the EPA to do it, right? We're going to need that kind of sort of specificity. The other wrinkle in this is that on the big major questions case, which was the OSHA vax or test case, the COVID era vaccine mandate case, Justice Gorsuch wrote in concurrence to that opinion, sure, I'm on board with major questions, but really, we could just strike this whole thing down into the non-delegation doctrine, right? So for the most of the court, they're comfortable at the moment saying, we might let Congress defer as long as it's really explicit about what authorities it's giving to the agency. But you do have some other justices on the court right now who are saying, we're not so comfortable with the idea of the administrative state writ large altogether, and we would be more comfortable striking down these authorities even if Congress was explicit that it wanted the agency to have that authority. So I think it remains to be seen. At the moment, that's not, Justice Gorsuch doesn't have the horn on that, and I think the court is not going to want to be that massively disruptive, right? There's going to be a step, some kind of reconstructed Chevron, and then we'll see how that goes. And then you're going to see iteration over the course of your young legalhood. But for those of you who are going to litigate, this is a huge thing you're going to have to deal with. Like, everything you're dealing with involves agency regulations. And you are going to have to figure out how you're going to litigate those cases, what kind of arguments you're going to make. this is probably the biggest legal question for you in terms of admin and con law for the next decade, I would think.
Why don't we take one more?
With your focus on preventative care and people now living longer than ever and a larger elderly population than when Social Security was passed in the Stone Age, life expectancy and retirement age are vastly different than what it was there. Professor Kaplan said that the trust fund for Medicare will never go bankrupt in his elder law class, but by 2040, I think is what he said, like it does go below where people aren't expected to get like the maximum of benefits, and the debt is going to be tripled by then. How do you expect we ensure that the elder population ensures 100% of their benefits whenever we are fully past this like bankrupt Medicare Social Security system?
Yeah, I think your teacher is probably much better educated to answer that question than I am, so I'm going to kick that question to him. Do you want to answer that, Richard? I mean, Nina's talking about sort of changing when you opt, like, so about people deciding for themselves sort of when they age into that. Is that one of the things you talked about? So Nina Cohn, who teaches elder care at Yale, has this argument about moving away from this idea of a certain age and thinking about each individual sort of when they want to age out of the work system and when they want to age into the retirement system, right? And thinking about Medicare in that way. As people work longer, not everybody is going to be able to work past 65, but a strong part of the population might be able to work past 65. So one of the ideas I've heard that's sort of interesting is that idea about thinking about different populations. But, you know, one thing that this case and all the ACA stuff really makes clear is just how precious Medicare has been and just how much we take for granted that we have this healthcare safety net for the older population that we all have. If we start to erode Medicare, which is sort of in the third rail, I think we would be in a lot of trouble. Just the fact that we're able to start pulling back on these preventative care benefits, I should have told you from the beginning. The CDC estimates that 180 million Americans took advantage of those benefits in 2020. And I think that number is underestimated because of the COVID vaccine, right? If you counted the COVID vaccine, it would be almost everybody. But that's a lot of people. And what's surprising about the Medicare question is the idea that people have come to rely on these programs for so long, that they're so entrenched, but that they can be destabilized. That in itself is quite destabilizing. And it's an important philosophical question that we've been struggling with for a very long time about what our overarching approach to healthcare should be. And that's why I sort of made that cute comment, like, why are we still fighting over this, right? But we are still fighting over it. The ACA is 14 years old or 14 years young, depending on how you think about it. If it survives another Trump administration, it will be even stronger. And the fact that it did survive the first one is a testament to the fact that it is, like Medicare, getting fairly entrenched.
Can we please thank Professor Gluck
Thank you, guys.
for visiting with us? As a thank you for coming to Champaign and the College of Law, we have a small gift.
Thank you.
So I believe that we have a few minutes, a reception in the pavilion, if you would like to speak more informally with Professor Gluck and his beautiful. Thank you all for attending.
Thank you for my talk.
Well, this was great. Thank you. Oh, it's better than okay. Not political, isn't it?
I mean, I gave a much more political version of this.
Oh, you did?
Hey, Jason, great to see you. I saw you on the faculty.